Hello. We are going to be looking at the historical roots of law in the beginning of our course, looking into the fundamental basics of what law is and what rule of law is for Canada. So let's get started with the historical roots. Now, if you're wondering why this is important, it is because history of law is long. And the legal system, as well as the traditions with the independence of the judiciary branch in Canada, is something that has taken a long, long time to, well, mature and to reach this point. And it helps to give students a much more broader, even like a big picture perspective of why the laws, why the legal system that currently exists in Canada is, well, that, why it is that case in the country. And so we start. The earliest laws in Canada, not, or even before Canada by a substantial kind of margin, the earliest forms of laws in the big picture, in a civilization case, basically came as existence of a form of rules from time that people really began to interact. We are basically going back quite a few thousands and thousands of years into the past. And with the earliest laws, it was based upon the common sense or what was the most practical. Laws also um, predate the establishment of any form of written language, known written recorded language. So laws were passed down by word of mouth as well as traditions. So, however, as the population started to grow, going past the early settlements like Jericho or Katayuk or Mesopotamia, the Yellow River, the Indus Valley, as early seeds of civilization essentially began to grow. Um, and we actually have civilization being established. With the population growing, the laws would become more complex as civilization, as we knew at that time, was also becoming more complex. Interactions, social hierarchy, values, do's and don'ts, things of that nature. And so as civilization grew, as civilization became more advanced, more with technology and numbers, issues even, it became a necessity that laws need to be put down into some sort of form of writing. And this realization, for lack of better words, was a commonality across all forms of civilizations, whether it's a civilization of the Indus Valley or the Yellow River, the Nile, the Tigris Euphrates, whatever the case was, it kind of organically grew from this point of view why laws were needed in the first place. And with the early form of laws, you can predate it to around 1280 to about 880 BCE. BCE is before Common Era because in Canada, at least, we don't use the terms um, before Christ, after death, as a way to time dates things, as that is no longer viewed to be politically correct. So that's why we use the term before Common Era or Common Era, as that's much more of a um, neutral term. So, with early formal laws that we currently know might come from India, well, as I said, 1280 year BCE, so give or take um, almost 4,000 years, give or take a few hundred centuries to reach that point. And the great laws of Manu were essentially a compiled numbers of laws that had been passed down orally from one generation to the next generation. However, in China, around 350 BCE, so just around, say, about 2,600 years ago, there was a code of Likivai, and these laws would include things of theft, robbery, prison, and arrest. And the Code of Lecrivi is important because that is the historical roots or historical origins of what we would look at or refer to as criminal law and civil law in the current legal system that now exists today in the early 21st century. So that's the early form of laws. The very first one that we know for sure that I kind of benchmarks or give us an indicator. And what I mean about that is if you look at history in the big picture, whether it's in a timeline or more of a holistic, um, wide angle lens, you will notice that there are certain documents that will appear throughout civilization history that really have the power that changes the course of civilization, changes the course of what life or the values were at that time. Now, some of these may not have been all that important at the original time of the creation, but from our perspective in the early 21st century, whether it's the Code of Lecrivi, the Justinian Code, the Magna Carta, Roman Republic, to name a few, Napoleon's for another one, these kind of documents really have the power of just altering civilization, history as we know, and it just cumulatively adds on top of the already growing pile of what the values of the history of law, the values of the rule of law, the independence of the judicial branch from the executive authority is all about. Now, going to the Code of Hammurabi, Hammurabi was a king of Babylon from about 1792 to 1750 BCE, so give or take about 3,000 plus years ago. But the main point of Hammurabi's code was that he codified the rules and the penalties for every aspect of life. He attributed his laws to the gods, and if you ever studied or looked into Mesopotamia, you know there was a lot of gods. There was dozens and dozens of them from big, powerful, scary menace ones to cute Cutly almost. But his laws were all were attributed to the gods because in Babylon, the area of Babylon, which was saddled between the Tigris and the Euphrates rivers, with the Zagros Mountains to the north, the Saudi Arabia desert to the south, it was kind of like that cradle of the civilization there. And so the pantheon, the house of the various gods, would vary from one city-state to another city-state. Actually, Mesopotamia, whether it's Babylon or Syria or whatever there actually was for them, in Mesopotamia, they had their deity, their patron gods in each of their city-states, and each city kind of was like its own government per se. But Hammurabi was the king of the area of Babylon, and he attributed his laws to the gods there, and kind of show the idea that if you're the wealthy elite or the powerful, you are given more protection than the poor were given there. And the Hammurabi's Code kind of really indicates the clear hierarchy of power. And he had created this code to, well, basically protect his supporters, protect his quote unquote friends, because well, if he didn't, they probably would have turned on him, and they did anyways. Actually, the history of Mesopotamia is actually a really violent history. When you really begin looking at it's just a constant battles and warfare, famines, droughts. It's amazing anything really got established in there, but that's a long, long time ago. But as I was going back to what I was saying about about this code and what's happening in Mesopotamia, on this map, you would see each one of these cities from Uruk or Ur, Nippur, Ashuna, Babylon, Sippar, Kersh, Eridu, Lagash. These were the various cities, and that's why I said these ones had their own patron gods, own set of governs. But this is where Babylon kind of existed in the cradle of Mesopotamia, but actually today this is essentially mainly Iraq and Kuwait is where these things were located. Unfortunately, now there was that unfortunate development what happened with ISIS, which did destroy quite a few of these ancient relics. But actually, because of 3D printing technology, some of the relics that the ISIS warriors destroyed are now being rebuilt for the better sake of humanity and for World UNESCO Heritage purposes. But to wrap up the idea with Hammurabi, it is Hammurabi's code is based on retribution and not restitution. As the old sort of cliche really goes with Hammurabi, it goes like this: if a son strikes his father, they should cut off the son's hand. There, and what it kind of that means essentially is it's eye for an eye. Hammurabi's code was really based upon vengeance and punishment, a way to deter certain acts from being done to create like a sense of forced obedience for the people who lived in the area of Babylon or ancient Mesopotamia. And in fact, actually, whether it's retribution versus restitution, you have eye for an eye versus payment for the offender. You have vengeance versus creating a common event for the theft of damage. They're essentially the Code of Hammurabi kind of is that first step, the first origin step of what is now referred to as criminal code. Criminal code is a code that deals with serious matters such as murder, treason, rape, and all the serious kind of matters, versus civil law, which is more contractual matters. There, the actual Hammurabi's code, pounded out in a canal form on the whole stone clay tablets, about 280 to have them fully deciphered and discovered on this tablet. But I've seen actually some reports that it would indicate on various other cuneiform tablets that Hammurabi's code might actually be around 600, 800. He actually literally just kept on adding to it, to his tablet and his code as it was required. And Hammurabi, he basically made no distinction between accident versus deliberate action. He favored the wealthy and the powerful, who often went unpunished. His laws were also often very excessive and cruel. He recognized that the strong should protect the weak. He made clear that people should not lie, especially during trial. Essentially, for the most part, many of those laws were reasonable and just that they were really punishing. And that's another of the historical origins with the Hammurabi's Code, especially when it comes to criminal law. The consequences are punishment as a form to punish on certain deeds that society has valued as unacceptable. So that's Hammurabi. Next one is the Mosaic Law, and it's also known as the Biblical Law or the Hebrew Law. Essentially, it's based upon the 10 Commandments and the similar basic principles of Hammurabi. Yet they were somewhat more involved. And one of the things that really make it distinguishable, one is it would punish a deliberate action and not an accidental action. And what I mean by that is, say, in the criminal code, you have manslaughter, or is it first or second degree murder? Was it an accidental death, or was it planned? Was it premeditated? That's kind of the idea between deliberate action versus an accidental action. The Mosaic Law began to establish that difference. Also, the Mosaic Law would likely punish the guilty party rather than the individual there. But the Mosaic Law did value the importance of looking after the poor people there versus the wealthy elite. So it's a way to sort of differentiate the difference between, because really by this point, this is still like 3,000, 2,000, 3,000 years ago, you have definitely the distinction of the wealthy elite and then everyone else there, that whole social hierarchy, upper class, lower class kind of perspectives. But with the Canadian legal system in particular, some of the things that it really has its origins from, well, the Bible was one, thou shalt not kill. How is it reflecting in laws today? Murder, first degree, second degree, accidental manslaughter. Another one is thou shalt not steal. Today that's theft, robbery, fraud. Um, for it there, and so you can see these other set of examples for it. But also, thou shalt not raise a false report or put thine hand on the wicked to be unrighteous witness. Essentially, do not lie, and kind of puts the value importance on using having a witness to any sort of crime. And so when we get to the criminal code, investigation and arrests, the elements of the crime assignment there, you'll see why it's important to have a witness to back it up, some sort of neutral party there, while the police are gathering their evidence. Another origin route would come from the Greeks. And from ancient Greece, this was the first form of democracy. Well, that's what kind of Greece was famous for. However, this is not the same kind of democracy that exists here in the early 21st century, where Canada, as long as you are a citizen of the country, you're 18 years or older, you can participate in the democratic process of electing a government, whether it's a federal, provincial, or municipal level, or because in Canada today we use representative democracy, but going back to the ancient Greeks, they were not that. Their form of democracy was a direct democracy, and only a small percentage of the citizens had the rights. Only a small percentage of the citizens were able to exercise the right to vote there. But despite that being the direct form of democracies, citizens were able to start participating in a jury system. And that's ultimately why I included Greece into this, because once we get to criminal law in particular, trials have juries to them. Jury basically represents the people, and of course, democracy demos the power of the people. So you have your judge by the people, the power of the people, and that's the jury, and the origins that goes to the ancient Greeks for it. But also, both sides could argue for a penalty for it, and like we do today, the jury will render their verdict, guilty or not guilty, and under the guilty verdict, then the judge would look over the criminal code if it's a criminal matter and see what form of punishments that links to Hammurabi would be applicable in this circumstance. This is going to be different from what you might sometimes see in the American system, where the jury may also give recommendations. But as we progress through this course, you will start to see some pretty substantial differences between the two legal systems, that being Canada or the United States. But as I mentioned before, right, the democracy, right, the actual word democracy comes from the ancient Greek word, which means demos, or the people. And the people, the jury representing, judged by the peers, whether you're guilty or not guilty of the charges that have been brought to you by the crown. From the Greeks, it's a natural progression to look at the Romans, because ultimately, when you are looking at historical perspectives, especially from a Western civilization point of view, Greeks and Romans are always included. So with the Romans, with the historical roots, Roman law was based upon two principles. One, law must be recorded down, and second, justice could not be left in the hands of judges alone. Essentially, what does that mean was that public prosecution of a crime, or a system of victim compensation, or protection for a lower class from upper class abuse, or a person seeking legal, a person could basically seek legal advice. Essentially, the first advisors. What does that basically means? We are talking lawyers. Lawyers, legal representation. However, this was not universal. This was only available to men, because women were still not mentioned under Roman law. And unfortunately, actually, under Roman society, women had not even just had no rights, women had no official status actually under Roman laws. But Roman civilization definitely was that keystone of civilization of in the West for it. But it's kind of a short one. Ultimately, we go from the Roman civilization, we lead up to the Byzantine Empire, and in particular, Emperor Byzantine. Essentially, Justinian's Code was a new body of law that was based upon the old Roman Code. He wanted to clarify and modernize a very complex law system that had already been adopted for a long, long time. But the point of Justinian's Code is look at his name. His name inspired a modern concept of what we refer to now as justice. One of the many systems that would influence Western civilization and the actual element of justice is found throughout all legal systems of law today. And the actual term justice is derived from the actual emperor's name, Justinian. Um, and his actual code in 529 Common Era. Continuing along with the idea of justice is the Magna Carta, also known as the Great Charter. The Magna Carta was signed by King Little John of England in 1215. Why the word little? If you're familiar with the stories of Robin Hood and Friar Tuck and the Sheriff of Nottingham, all those kind of stuff. Essentially, the Magna Carta, even though it did lead to actual civil war of the 25 barons, did lead the movement of protecting the individual rights against the authorities. What does that mean essentially? The Magna Carta essentially established the precedent that no one is above the law of the land, not even the king. Everyone is susceptible, everyone must adhere to the laws of the land there. That is how rule of law is and continues to be maintained. That is the true power of the Magna Carta. For it establishes the rule of law. Yeah, in the rule of law has been established for a long time, but the rule of law that no one is above it. Like as mentioned, Hammurabi, he protected the wealthy elite. The Mosaic Code tended to protect the lower class. The Magna Carta kind of let the groundwork for everyone is sustained, which we put into today's values. Of course, today, early 21st century, in the Canadian legal system, everyone is more or less the same, except for the young offenders. And the Canadian Criminal Code, that's the exception there, but there is a rule of law, and no one is above the rule of law. And you could also argue, too, the Magna Carta, it will be one of those founding documents along with the French Declaration of Rights of Man and the Citizen, or the American Declaration of Independence, can all lead up to the whole human rights, the Declaration of Human Rights there. But for today, we'll end it with the Napoleonic Code of 1804. And the Napoleonic Code was developed after the French Revolution with the whole guillotining King Louis and Marie Antoinette, all that stuff there. But the Napoleonic Code came after the French Declaration of the Rights of Man and of the Citizen. That was from the General Assembly and Maximilien Robespierre. But the Napoleonic Code is also known as a French civil code. Essentially, it was very popular. It was simplistic, accessible to all people of the average person, but it regulates civil matters, right? And we're starting to talk about there's a difference between criminal law and civil law, family law, constitutional law, international law. Napoleonic Code really kind of helped establish civil law, and that is property, wills, contracts, marriages, divorces, family law there. And it kind of outlined what would be civil law and what is not relatable to the criminal code. And that is a little look into the history of law.